You might be wondering, why are we holding Law Day in the month of September of every year? Just a quick introduction to that question, well, kahit wala naman nagtatanong, no? It's actually because of Proclamation number 713, series of 2004, that declared September as the Rule of Law Month. Gives us a clear indication that the government recognizes that our Constitution ordains a society where the rule of law and justice prevails. More than that, it recognizes the need for the promotion of the rule of law in the crucial value formation of the youth, not just law students, but for the younger generation. Today, as we gather we gather and celebrate the Philippine Law Week, we not only honor our legal traditions and accomplishments, but also reflect on the significance of the rule of law in addressing contemporary challenges. This week signifies a time for us, as future and current custodians of justice, to examine the legal principles that uphold our society and guide our actions, both domestically and on international fronts. This year's celebration is particularly pertinent as we navigate complex issues such as the ongoing dispute between China and the Philippines over the West Philippine Sea. This situation serves as a compelling example of why rule of law is fundamental in maintaining peace, ensuring justice, and protecting national sovereignty. Although sometimes overlooked, the significance of legal education in the country is immense. Not only does it shape how laws are interpreted and enforced, but it also heavily influences the quality of legal services we offer to the public, which is the very foundation to some of the basic structures of our government, and in turn, our society. The mandate of all legal professionals is to act as stewards of justice, officers of the court, defenders of the rule of law, and builders of legal frameworks. By promoting excellence and quality in the level of legal education we offer in our law schools, we ensure that future generation of lawyers and legal scholars will be well equipped to meet the demands of their roles and to serve the public with both integrity and skill. By investing in and promoting excellence in our legal education institutions, we not only enhance the professional skills of our individual practitioners, but more importantly, we are reinforcing the overall integrity of our legal system, and by extension, the fairness of our society and the country as a whole. As we continue to celebrate Law Month, and even in the months to come, we at the Legal Education Board look forward to offering lectures on critical issues, where each listener can gain insights into various areas of law and legal practice from the experts themselves. These events are, after all, designed to foster continuous learning and dialogue, helping us all to stay at the forefront of legal developments and trends in the modern world. Today's lecture on the Philippine Island territories in the West Philippine Sea is a perfect example of how specialized knowledge contributes to our broader understanding and approach to critical issues that affect our fellow Filipinos. International laws, particularly the United Nations Convention on the Law of the Sea, provide framework for resolving disputes such as the one we're facing now. The Philippines' historic legal victory in 2016, where the Permanent Court of Arbitration in The Hague ruled in favor of the Philippines, is a testament to the power of law as an instrument for asserting and preserving national rights. This ruling underscored the importance of upholding international legal standards and demonstrated that reason and justice can prevail over might and coercion. For all of us engaged in the study and practice of law, these events remind us of how critical of our critical role in advocating for and upholding these principles. We must remain steadfast in our commitment to the rule of law, for it is not merely a theoretical pursuit, but a vital mechanism through which we seek justice and equity in both local and global contexts. More importantly, it requires us to do specific acts within our power to ensure that the rule of law is always upheld. We are privileged to have with us a distinguished keynote speaker who exemplifies these ideals. Actually, he need not be introduced in detail because his work speaks for itself. Former Justice of the Supreme Court, who has dedicated his career to the service of justice. His insights and experience enrich our understanding and inspire us to pursue legal endeavors with integrity and dedication. His passion for educating people about this issue is beyond question and is truly admirable. Born in Davao City, Justice Antonio T. Carpio was sworn in as a member of the Supreme Court of the Philippines on October 26, 2001. He served in the Supreme Court for 18 years, retiring on October 25 of 2019 upon reaching the compulsory retirement age of 70. Justice, mukha pong bata kayo sa age nyo. Justice Carpio retired with zero backlog of cases. Justice Carpio obtained his law degree from the College of Law of the University of the Philippines, where he graduated valedictorian and cum laude in 1975. He earned his undergraduate degree in economics from the Ateneo de Manila University in 1970. Fresh out of law school, Justice Carpio went into private practice and founded the Carpio, Villaraza and Cruz law firm. He was a professorial lecturer of the UP College of Law from 1983 till 1992, when he was appointed Chief Presidential Legal Counsel with cabinet rank, the Office of the President of the Philippines, for his distinguished and exemplary service to the Republic. Justice Carpio was awarded in 1998 the Presidential Medal of Merit by then-President Fidel Ramos. He was conferred a Doctor of Laws honoris causa by the Ateneo de Davao University in 2009, by the University of the Philippines in 2020, and by the Ateneo de Manila University in 2021. On October 29, 2011, as guest speaker of the 50th founding anniversary of the Ateneo de Davao College of Law, Justice Carpio launched his advocacy to challenge the validity of China's 9-dash line before a tribunal under the United Nations Convention on the Law of the Sea. Ever since, he has been giving lectures all over the country on the invalidity of China's 9-dash line. In 2015, the Department of Foreign Affairs sponsored Justice Carpio on a world lecture tour on the West Philippine Sea dispute. Justice Carpio presented the Philippines' perspective on the dispute before think tanks and universities in 30 cities covering 17 countries. In May of 2017, Justice Carpio published the book titled The South China Sea Dispute, Philippine Sovereign Rights and Jurisdiction in the West Philippine Sea. While in the Supreme Court, Justice Carpio served as chair of the Second Division of the Supreme Court and chair of the Senate Electoral Tribunal. Unquestionably an expert in this field, please join me in addressing our deepest gratitude to our esteemed keynote speaker for his invaluable contributions to the judiciary and his unwavering commitment to the rule of law. And as we celebrate Law Week, let us reaffirm our dedication to these principles and our responsibility as legal professionals. Thank you, and may this be an enlightening and transformative experience for all of us Again, welcome to the Angara Lecture Series.
Thank you very much, Chairperson Barlis, for the very warm introduction. Now, without further ado, may I invite Justice Carpio to the virtual stage to share his lecture. Let us warmly welcome Justice Antonio T. Carpio with a virtual round of applause.
Thank you for that very kind introduction, Chair Barlis, and a pleasant afternoon to everyone. May I ask to share share my PowerPoint presentation?
Okay na po.
Can you see it now, my PowerPoint? Can you see my PowerPoint already?
Not yet po, Justice.
Sandali ah.
Ayan.
Okay, thank you. This afternoon, we will answer the question, what are the island territories of the Philippines in the West Philippine Sea, and why do we say that these territories are part of Philippine territory under Philippine sovereignty? We're talking about Bao de Masinloc or Scarborough Shoal, and also the Calayan Island Group. We are claiming now the high tide features and the 12 nautical mile territorial sea around the islands of the Calayan Island Group. If you look at the map, this is the line of the Treaty of Paris. Scarborough Shoal is outside the line. The Spratlys are outside the line. So why do we say that the Philippine territory includes Bao de Masinloc and the KIG group when these islands are outside the treaty lines of Paris? The greatest misconception in Philippine history is that Philippine territory is limited to the islands within the lines of the 1898 Treaty of Paris between Spain and the US. This is factually, legally, and historically false. And this false narrative has misled many Filipinos, and it has misled the rest of the world, and it has emboldened China to claim the Spratlys and Scarborough Shoal. Now, in 2009, the Philippine Judicial Journal published an article of former Solicitor General Estelito Mendoza. And in that article, former Solicitor General Mendoza said that it must be remembered that the Calayan Island Group came to be part of the Philippines only upon the enactment on June 11, 1978 of PD 5096. It has never, through the centuries of its existence, been regarded as part of Philippine archipelago. Now, if we claim the KIG group starting 1978, then we will lose because China claimed it much earlier. If you go to the YouTube, you will see this video of former Senate President Enrile, who is now the Chief Presidential Legal Counsel. He said, alam mo yung Scarborough, hindi sa atin yan. Squatter lang tayo doon. It's outside the Treaty of Paris. He said this in March of 2021. And because of this misinformation, this has misled China. And in just before the arbitral award came out in 2016, Chinese Foreign Minister Wang Yi, in a very important policy speech at the CSIS in Washington, D.C., that's the leading think tank in Washington, D.C., before diplomats from all over the world, Foreign Minister Wang Yi said, there are 3 treaties that stipulate Philippine territory, the 1898 Treaty of Paris, the 1900 Treaty of Washington, and the third, the Treaty with the British of 1930. This regulated the Philippine territory at the 118 degrees east longitude. That's the western boundary of the Philippines. Areas in the west of the 180 degrees east longitude do not belong to the Philippines. Nansha, that's the Spratlys claimed by the Philippines, and Wangyan Island, that's Scarborough Shoal, are all in the west of the 118 degrees longitude. So if you look at the map, you can go to YouTube and see this. These are the lines of the Treaty of Paris, and this is the 118 degrees longitude that Foreign Minister Wang Yi was mentioning. Scarborough Shoal, it's outside the treaty lines. This entire Spratlys are outside the treaty lines. So Wang Yi said very clear that Scarborough Shoal and the Spratlys are not part of Philippine territory. Now, this is completely wrong. It is imperative to correct once and for all this dangerous misconception, this greatest misconception in Philippine history. We start with the Article 1, Section 1 of the 1935 Constitution, which says Philippine territory comprises of the territory ceded to the United States by the Treaty of Paris, that's between US and Spain, that's the 1898 treaty. So the Philippine territory comprises of all territories ceded under the 1898 Treaty of Paris, together, this is the second treaty, together with all the islands embraced in the treaty concluded at Washington in 1900. So from here, you will see that Philippine territory is not limited to the islands ceded in the Treaty of Paris. There is another treaty, the Treaty of Washington of 1900. And there is a third treaty, the treaty between the US and the UK, demarcating the boundary in southern Philippines. Let's drill down to the Treaty of Paris. The Treaty of Paris says the archipelago known as the Philippine Islands is the islands lying within the following line were ceded by Spain to the US. But there was a second treaty because when the Americans came here, they found out that there were other islands belonging to the Philippine archipelago lying outside the lines. So they finally had a second treaty to include other islands of the Philippine archipelago lying outside the line. So the second treaty says Spain also ceded to the US any and all islands belonging to the Philippine archipelago lying outside the lines. So from here, you will know that that narrative that Philippine territory is limited to the islands within the treaty lines is totally false. What Solicitor General Mendoza said and really said is totally false because Philippine territory included islands lying outside the lines. We go to the third treaty, the treaty with the British, and that treaty defines Philippine archipelago. And the Philippine archipelago refers to the territory acquired by the US in the Treaty of Paris of 1898 and the Treaty of Washington of 1900. So these are the three treaties that demarcate Philippine territory. Now, there is a fundamental principle of international law. It's called uti possidetis juris. It roughly translates, as you possess under the law, stay there. This is a principle of international law designed to preserve peace and stability in the former colonies of the colonial powers. If you look at the map of Africa and Latin America, you will see that the boundaries of the countries are drawn in straight lines, straight horizontal lines and straight vertical lines. One tribe may live on one side of the boundary and members of the same tribe may be living in the other side of the boundary. If you allow them to fight to get these other members of the tribe to live on one side or to get the territory so that they will be whole, there will be perpetual boundary wars. So the international law developed this theory, this doctrine, as you possess under the law, stay there, because there will be perpetual boundary wars if you allow them to claim members of the tribe living on the other side of the boundary. The colonial powers simply drew straight lines without considering where those tribes lived. So to address that problem, international developed this principle. This principle applies to Latin America, to Africa, and Europe, and rather Asia, and wherever there was there were colonies by colonial powers that became independent later on. So the principle says that the boundary established by colonial powers in their former colonies at the time that these colonies became independent are sacrosanct. They must be respected by all states, by the world, not only by those who entered into the treaty. This is binding on the world. And as to the Philippines, we have 3 treaties. The first, 1898, between Spain and the US. The second, the Treaty of Washington of 1900 between Spain and the US. And the third, between the US and UK, demarcating the boundary in southern Philippines. These 3 treaties are governed by the uti possidetis juris. And Philippine territory, when we became independent on July 4, 1946, are defined by these 3 treaties, and the world must respect these 3 treaties. Now, so what are the islands of the Philippine archipelago covered by this uti possidetis juris? When you look at the Treaty of Paris lines, you know exactly what are the islands of the Philippine archipelago. But the question is, what are the islands of the Philippine archipelago lying outside the lines of the Treaty of Paris that are also governed by the uti possidetis juris principle? Where is that document? Where is that map that shows that Philippine territory includes those islands lying outside the treaty lines of the Treaty of Paris? We start with the 1734 Murillo Velarde map. This is an official map of Philippine territory. The first official map of Philippine territory during the Spanish regime. And you will see here Panakot as part of Philippine territory. Panakot is the first name given to Scarborough Shoal. That's Panakot. The Europeans later renamed it Scarborough Shoal. And you will have here Los Bajos de Paragua. Paragua is the old Spanish name of Palawan. Los Bajos means shoals, the shoals of Palawan. Those are the Spratlys. In the 1700s, this is how they depicted shoals in map. This is how cartographers depicted shoals in map. So Los Bajos de Paragua refers to the Spratlys. So in 1734, Spain already claimed Scarborough Shoal and the Spratlys. This map was drawn here in Manila. If you will see here the cartouche, this is the Royal Crown of Spain. And if you see the Royal Crown of Spain in a map, then that is an official map of the Crown of Spain. And because in 1733, King Philip V of Spain directed Governor General Tamon here in Manila to make that map, and Father Pedro Murillo Velarde, a Jesuit priest, made that map. It was made here in Manila. So we go to Scarborough Shoal. In 1792, Alessandro Malaspina came to Manila. Who was Alessandro Malaspina? He was the head of the Spanish scientific expedition that was sent all over the world to collect specimens of flora and fauna in the Spanish possessions and to chart the Spanish waters overseas. And when he arrived here in Manila in 1792, he went to Scarborough Shoal on May 4, 1792, because Scarborough Shoal became very famous. Of course, the Spaniards called it Panakot, but the European cartographers renamed it Scarborough Shoal when the British tea clipper ship ran aground on Scarborough Shoal. So the European cartographers renamed it Scarborough Shoal. And so Malaspina went there and conducted the first hydrographic survey ever of Scarborough Shoal, 1792. He conducted the hydrographic survey by using this plummet. This is lead attached to a thin wire. You drop the lead and you will measure the depth of the waters around the rocks so that navigators can avoid those rocks. They will know how deep the waters are around those rocks. So this is the first survey of Scarborough Shoal. And at that time, China didn't even know that a shoal called Scarborough was existed. Now, in 1808, Spain published the second official map of the Philippines, the 1808 Carta General del Archipelago Filipino. And there is something very unique about this map. The survey of Malaspina was included in the map. So this map shows Scarborough Shoal with depth soundings, and this is the only geologic feature in this map that has depth soundings. All the other islands of the Philippine archipelago, I'll show you the second part of this map, all the other islands had no depth sounding. So this is a very unique map because the survey of Malaspina was inserted in this map. Why? Because the director of the mapping agency, the Dirección Hydrografía, the director of the mapping agency at the time of Spain, was a fellow named Joseph Espinosa. And he was an officer of Malaspina. And he was with Malaspina here in Manila, and he was with Malaspina in surveying Scarborough Shoal. So when he became director of the Dirección Hydrografía, the mapping or charting agency of Spain, he inserted the survey of Scarborough Shoal that they made in May of 1792. So this is the entire map. You can see here already the islands in the Spratlys, not yet complete because they were still going around and surveying the islands in the Spratlys. Then we come to the third official map, the most important map, and I call this the Holy Grail map. And this is the most detailed, most complete map of Philippine territory during the Spanish regime. And you will see here, of course, Scarborough Shoal with depth soundings. And you will see here the entire Spratlys with names, with depth soundings. Because the maker of this map, Claudio Montero, a Spanish officer who was detailed here in the Philippines for a very long time. He headed the Hydrographic Commission, Philippine Hydrographic Commission during the Spanish regime. He had two ships that went around the Philippines to conduct depth soundings. And here you will see the entire Spratlys with depth soundings. Unfortunately, we do not have a copy of this map. So if you have a house and lot, what is your proof of ownership? Your title, your TCT. This is our TCT, but we don't have a copy of this map. I downloaded this from the Ministry of Defense of Spain. You can download it for free. This is a high-resolution copy. And unfortunately, none of our public museums or public libraries has a copy of this map, and not even our private collectors has a copy of this map. But I'm hunting for a copy of this map now. So this is the map that answers the question, what are the islands of the Philippine archipelago lying outside the lines of the Treaty of Paris? This is the document. This is the map that answers that question. So this map, when the Americans came here after signing the Treaty of Paris in 1898, they did not have a map of the Philippines. So what they did was they adopted this 1875 Spanish map of the Philippines. They adapted it completely. They just added certain lines to show the telegraph lines, the military district lines, and so on. But exactly the same map with depth soundings. And you will see here, this was the map, 1901 edition of the map, War Department, Adjutant's Office of the U.S. The War Department. So this is the most complete map of the Philippines during the Spanish regime that was adopted also by the Americans. So the map was adapted in four editions. As I said, it contained the military telegraph lines, cable lines, and so on, but exactly the same map. The Americans just superimposed these lines. So we have this map. And if you look at the Spratlys, you will see here Tito. Tito is Pag-asa. This is the boundary edge of Philippine territory under 1875 map. You will see here Loita. That's Kota. We call this Kota. It's Loita here. And this is Ituaba. That's the largest island in the Spratlys, about 47 hectares, presently possessed by Taiwan. Tito or Pag-asa is about 37 hectares, and the Loita or Kota is about 12 to 14 hectares. Now, let us examine Scarborough Shoal in three maps. This is the 1734 Murillo-Velarde map. You have Scarborough Shoal, called Panakot. And this is the 1808 Carta General. You have Scarborough Shoal with depth soundings. And this is the 1875 map, Scarborough Shoals or Maho de Masinloc with depth soundings also. So China has no map like this. They probably didn't know that Scarborough Shoal existed. Now, in the Spratlys, this is the Namria map of the Spratlys. These are the KIG lines under PD 5096. And we are claiming now, because we corrected our claim to align with UNCLOS under Republic Act 9522, we are now claiming only the high tide features and the 12 nautical miles. Under the old law, we claimed everything within the polygonal lines, and we claim even beyond 12 nautical miles. We claim low tide features. The rule is you can only claim as territory high tide features. So we are compliant now with UNCLOS because of Republic Act 9522. But this is the present day map. Now, if you compare the present day map, this is the edge of Philippine territory under the present day map. You can see here Pag-asa. You can see here Kota. You can see here Ligao. Ligao is Ituaba, Kota is Loita, and Pag-asa is Tito. Tito, Loita, and Ituaba. We call Ituaba Ligao. So the Treaty of Paris was signed in 1898. Spain paid $20 million for the cession. What was transferred to Spain were the islands comprehending the islands lying within the following lines. So only the islands within the lines. It did not convey to the US islands lying outside the lines. Okay. Very few know that the Treaty of Paris had a map attached to it. There was a map, and this is the map. And this is very revealing because in the map that was attached to the Treaty of Paris, the lines of the Treaty of Paris in the West Philippine Sea turned sharply to the left to include the entire Spratlys and to include Cagayan de Sulu, Cebuto, and everything. The only thing missing here is Scarborough Shoal. So this is the map. When the Treaty of Paris was signed, it was submitted by the US President to the Senate for ratification. And this is the map that the US Senate were looking when they ratified the Treaty of Paris. They said, oh, okay, Spratlys are there, the Cagayan de Sulu and Cebuto are there, so okay, we ratify. So they ratified it based on this map. But there was a problem because the Treaty of Paris, in the text of the Treaty of Paris, the geographical coordinates of the lines were stated. Longitude, latitude. And if you connect the lines, the dots, the longitude, latitude, you will get this. You will get this in Palawan. The lines do not turn sharply to the left to include the Spratlys. It turns downward to exclude the Spratlys. And it turns sharply to the right to exclude Cagayan de Sulu and Cebuto. So there was a mismatch. There was a difference between the map and what was stated in the text of the treaty. Of course, the text will prevail. And that was the problem. When the Americans arrived here, when they went to Cagayan de Sulu and Cebuto, the Spanish garrison there refused to vacate. They said, we are not included in the session. We're outside the treaty lines. So the Americans said, okay, let's do the Spaniards so that we can clarify that everything, all the islands in the Philippine archipelago were actually included. So the US sent this note verbal to the Spanish ambassador. They said, our intention when we signed the treaty was that all the territorial sovereignty and title of Spain in that part of the world will be transferred to us. Everything, the entire Philippine archipelago should be transferred to us. That was the intention. And the Spaniards replied, we were defeated in the war. You dictated to us the terms. You dictated to us the geographical coordinates. And what are excluded from those geographical coordinates were not transferred to the US. We still retain sovereignty over islands of the Philippine archipelago outside the lines of the Treaty of Paris. So there was this acrimonious exchange of notes. And finally, the Americans said, okay, we will pay you $50,000 more on top of the $20 million that we paid you, so we can clarify that all the other islands of the Philippine archipelago lying outside the lines were included. The Spaniards said, that's too little. So the Americans doubled it to $100,000, and the Spaniards said, okay, we agree, we will sign a clarification. And that clarification, according to the Spanish ambassador in Washington, he sent a communication to his boss, to his minister in Madrid. He said, there is only one article in the Treaty of Washington drawn in such a manner as to comprehend, to include other islands outside the limits of the Treaty of Paris. So all other islands of the Philippine archipelago lying outside the lines of the Treaty of Paris will be ceded also under this treaty. And so the treaty was signed, and this is how it's worded. Spain also ceded to the US any and all islands belonging to the Philippine archipelago lying outside the lines of the Treaty of Paris, as if they have been expressly included within those lines. As if they had been expressly included within those lines when the treaty was signed in 1898. So it even retroacted to 1898. And so, very clear, Spain, the intention of the Americans was that everything, all islands of the Philippine archipelago in that part of the Pacific should be transferred to the US. And that intention, there was now a meeting of the minds when this Treaty of Washington was signed. They actually agreed that all islands lying outside and lying within the lines are ceded to the US. There was a meeting of the minds when the Treaty of Washington was signed. So, the entire Spratlys were ceded. It's there in that map. And that is the meaning of the Treaty of Washington. Now, so there was a meeting of the minds. So it's very clear that the Spratlys belong to the Philippines. And under the international principle of uti possidetis juris, all the nations of the world must respect this. Now, in 1938, the Philippines was run by the Commonwealth government, and these are now the Filipinos running the Philippines. And they said some country might claim Scarborough Shoal. So let us put a lighthouse on Scarborough Shoal as a marker that it's under Philippine sovereignty. But they said, we want to clarify that it's really Scarborough Shoal is really part of Philippine territory. So they wrote Secretary Colonel Hall of the U.S. State Department. He was a Secretary of State, and he replied, because there are no other claimants, because of the absence of other claims, the shoal should be regarded as included among the islands ceded to the U.S. in the Treaty of Washington of 1900. So there you are. Scarborough Shoal is one of the islands lying outside the lines of the Treaty of Paris that was ceded to the US in the Treaty of Washington of 1900. This is an official communication of the US, and they are bound by this. The US is bound by this. This applies the Treaty of Washington. The first application of the Treaty of Washington, that Philippine territory includes any and all islands of the Philippine archipelago lying outside the lines. One of them is Scarborough Shoal. So that's Scarborough Shoal. It's there in the 1875 Carta General, even in the 1734, even in the 1808. Now, so we go back to the question, what is our frame of reference? When we say any and all islands belonging to the Philippine archipelago lying outside the lines, what is our frame of reference? We go to the maps, the official maps of Philippine territory during the Spanish regime, the 1734, the 1808, and the 1875, the most complete and detailed map of Philippine territory during the Spanish regime, which the US adopted also. Because just before the Treaty of Paris was signed December 10, and before the end of the year, 20 days later, the US issued its first map. They adopted the 1875 map right after signing the Treaty of Paris before the end of that year. 1900, before the signing of the Treaty of Washington, they issued another edition. 1901, after the signing of the Treaty of Washington, they issued another edition. And finally, they issued the 1902 edition. So this is now really our Torrens title, because this is now the map that's covered by the Uti Possidetis Juris principle. The world must respect Philippine boundaries in this map, because this is included in the treaties that define Philippine territory. Now, there was this famous case in international law, very famous case, is the Islas Palmas case. Islas Palmas is an island in the east coast of Mindanao, opposite Sarangani, and this was discovered by the Spaniards. It appears in the 1875 map. It's there. Islas Palmas, part of Philippine territory. One day, the American Governor General at that time was sailing in Mindanao, and he saw the Dutch flag flying in Islas Palmas. And he said, that's part of Philippine territory. How come the Dutch flag is there? So he inquired. It turns out that the Dutch had claimed it, and the flag of the Netherlands was flying. So they submitted it to arbitration. The US and the Netherlands were friends at the time, so they submitted it to arbitration by Max Huber, very famous case, international law. So the question is, Spain, admitted by the US that Spain discovered it. But it was the Dutch that actually exercised sovereignty over it. So in that arbitration, the US, to prove that Islas Palmas is part of Philippine territory, submitted the 1875 Carta General, the map we're talking about. And this is the memorandum of the US, pages 42 to 43. The US said, this exhibit, this map, is both an American official and Spanish official map. So there you are, an admission by the US that this 1875 map is an official map of Philippine territory under the American regime. The Spaniards, of course, considered it also the official territory of the Philippine archipelago during the Spanish regime. So this is Sarangani, this is Mindanao, Davao is here, and Islas Palmas is here. So how did Max Huber decide the case? Max Huber said, okay, discovery gives you an inchoate title, but to complete your title, you must show continuous and peaceful display of sovereignty. And it was the Netherlands that showed continuous and peaceful display of sovereignty. Why? Because the Dutch went there to sign a treaty with the locals. About 700 people live there, and the Datu, or the chieftain, signed a pledge of allegiance that we recognize the sovereignty of the Netherlands over our island. And they flew the Dutch flag. And Max Huber said that is continuous and peaceful display of sovereignty. So Islas Palmas belong to the Netherlands. And today, Islas Palmas is part of Indonesia. But Max Huber left us with something. He said, I am deciding this case in this way because the island is inhabited. There are 700 people living there. But if it is not inhabited, if it is uninhabited, the ruling will be different. So, but he stopped there. He did not explain. He said, because this is inhabited, and the inhabitants pledge allegiance to the Netherlands, then there is a continuous and peaceful display of sovereignty by the Netherlands. Now we go to the next case 3 years later, the 1931 Clipperton Island case. In this case, the French went to, the French officer aboard a commission ship went to Clipperton Island. That's a very remote island off the coast of South America. The island is uninhabited. It's also uninhabitable because there's no water there. And the French naval officer read a proclamation. France today claims this island as part of French territory. That's it. And he went to Hawaii, the nearest island with the government, and took out a 2-by-2-inch advertisement in a Hawaiian journal. Today, France claimed Clipperton Island. France never returned to the island for 39 years. When in 1897, Mexico claimed the island. So there were 2 countries claiming the same island, and they decided to submit to arbitration by King Emmanuel. And King Emmanuel decided it this way. He said, the fact that it was completely uninhabited, because it was completely uninhabited, there were no other claimants. From the moment when France appeared there to declare that it is part of French territory, that is an absolute and undisputed disposition. That title is complete already. So when France appeared in that island to proclaim it as part of France, there are no other claimants. It's completely uninhabited. The title of France became complete. It became complete upon discovery because there were no inhabitants. The French, even if they went there to try to get, they will never get the crabs and the turtles to sign a Pledge of Allegiance. Nobody was there to sign a Pledge of Allegiance. So that is the ruling. In the next case, the 1933 Eastern Greenland case, in the 1700s to the 1800s, Denmark claimed and populated Greenland, but only the warmer areas in the western side. Denmark did not populate the eastern part because it's very cold. It's inaccessible. You cannot live there. In 1931, Norway claimed the eastern part. And so they decided to submit it to arbitration. And the court said, the ruling of the Permanent Court of International Justice, bearing in mind that there are no other claimants at the time that Denmark claimed it in the 1700s up to the 1800s, and it is inaccessible, the area is inaccessible, it cannot be colonized. The title of Denmark became complete upon that discovery in the 1700s. So this now reaffirms the Clipperton Island case. If the island is uninhabited or uninhabitable, the mere fact of discovery vests a complete title. Because the law, of course, does not require you to do the impossible. The law will not require you to inhabit the eastern part, which is uninhabitable. So that is the law up to now, and we apply it to the Spratlys. In 1734, Spain claimed the Spratlys, reiterated it in 1808 up to 1875. There were no claimants all these centuries. France claimed it only in 1933. So from 1734 to 1933, there were no other claimants except Spain. And because it is the Spratlys are uninhabitable, the July 16, 26, July 12, 2016 Arbitral Award at The Hague said there is no historical record of human habitation in the Spratlys because it is not capable of human habitation on its own, based on its own resources. There is no water in the Spratlys, in all the islands. Only when it rains, you can find water in the aquifer, but after a few months, it's gone. So it cannot support human existence unless you import, you have a desalination plant, which is happening now. But the criterion is it must be based on the natural resources. It must be habitable based on natural resources. So because the Spratlys were uninhabitable, there were no inhabitants when Spain claimed it in 1734. The title of Spain became complete in 1734. So there you are. We completed our title in 1734 because these islands were not habitable then, and even now you cannot live there based on the natural resources of the island. So how do we depict now in the internet, in maps, Philippine territory? You have the Treaty of Paris lines. You must draw another line to enclose Scarborough Shoal, to enclose the KIG group, because the Treaty of Washington of 1900 said, as if these islands lying outside the lines were included within the lines. You cannot transfer the islands here. So you just enclose it with lines again. This is how we should depict Philippine territory to ourselves and to the world. We must have another line here to say that that is the Treaty of Washington. Because of the Treaty of Washington, we have title over this. Now, Namria today is planning to come out with a new map of the Philippines, and this is it. You have the Treaty of Paris lines, but there is no line, there are no lines saying that Scarborough Shoal is part of Philippine territory. If you go to the legend of the map, this is the legend of the map, this is a blow-up, they listed the Treaty of Paris of 1898. They jumped to the US-UK Treaty of 1930. They omitted the Treaty of Washington. So how can we say that the Spratlys belong to us or Scarborough Shoal belong to us when we don't mention the Treaty of Washington? We have to include the Treaty of Washington here and show Scarborough Shoal as part of the treaty. So I told them if they can please include the Treaty of Washington, because it is the most important treaty today in our dispute in the West Philippine Sea. Now, UK signed a treaty with the US in 1930, and in that treaty, it defines the Philippine archipelago, as I mentioned. The Philippine archipelago is the territory acquired by the US under the Treaty of Paris of 1898 and the Treaty of Washington of 1700. And this is reiterated in another whereas clause, Philippine archipelago, the territory acquired. So UK signed this treaty and it will bind. It is binding on Malaysia. Malaysia is the successor of UK in British North Borneo. So Malaysia cannot claim the Spratlys because UK admitted that Philippine territory is regulated, defined also by the Treaty of Washington. And the Treaty of Washington says any and all islands belonging to the Philippine archipelago lying outside the lines were ceded to the US. In 1943, China published the China Handbook. It's published by the Chinese Ministry of Information. And in Chapter 1 of that handbook, this is official publication of the Chinese government, they defined the Chinese territory. Their southernmost territory is Triton Island of the partial group to the south of Hainan. So we are already in 1943, and China has not yet claimed the Spratlys or Scarborough Shoal. They said their southernmost territory is Triton Island of the Parcel Group. This is the nearest island to South Vietnam. You have to cross the South China Sea high seas to reach the Spratlys or Scarborough Shoal. So China did not claim the Spratlys as late as 1943. They never claimed it. This is the book. I have a copy of this book. In 1947, China revised the handbook. And in this handbook, 1947, for the first time in Chinese history, China claimed the Spratlys. They called it the Coral Islands, Tuansha Islands. They claimed it, but China said it is also contested. It is also claimed by the Philippines, contested among China, Commonwealth of the Philippines, and the French in Indochina. So China said we're claiming the Spratlys, but this is also claimed by the Philippines. That is a fatal defect because you can claim only an island if it is terra nullius, land that belongs to no state, terra nullius. In 1947, when China claimed it, it was not terra nullius anymore because one, we claimed it since 1734, and even France claimed it in 1933. So there is a fatal defect in that Chinese claim. Now, in the arbitration at The Hague, China said, we are not participating, but this is our position paper. They submitted a position paper, and the tribunal said, okay, we will treat your position paper as your comment. And in that position paper, China said, Philippine territory is regulated by 3 treaties. The Treaty of Paris, the Treaty of Washington, and the treaty with the British. That has been their mantra. Philippine territory is limited to the islands within the treaty lines based on the Treaty of Paris, the Treaty of Washington, and the treaty with the British. They were misled by our legal luminaries, by former Solicitor General Estelito Mendoza and by Ponce Enrile. So we should thank these two guys for misleading the Chinese. They now admit that Philippine territory is governed also by the Treaty of Washington. They are bound by that. They cannot get out of it. They're in stoppel. They admitted it before a judicial body, and that's the highest form of admission. An admission before a judicial body is the highest form of admission. China cannot get out of that. They said Philippine territory is governed by the Treaty of Washington also. That's it. They never read the Treaty of Washington, and they never examined, they never looked into the history why the Treaty of Washington was signed. But they just said, we are bound by the Treaty of Washington. We believe, we accept that Philippine territory is governed also by the Treaty of Washington. That's a fatal defect of it. So, in conclusion, what are the islands of the Philippine archipelago lying outside the lines of the Treaty of Paris? You go to the Treaty of Washington, and we also have the treaty with the British. There are 3 treaties governing Philippine territory. Treaty of Paris of 1898, Treaty of Washington of 1900, and the treaty with the British. And to determine what are the islands lying outside the line, you have to go to the maps. Official maps of Philippine territory, the 1734 Murillo-Velarde map, 1808 Carta General, and the 1875, the Holy Grail map, I call this, 1875 Carta General del Archipelago Filipino. So, what is my recommendation? We should challenge China, Vietnam, Malaysia to submit the territorial dispute to arbitration, because there are 2 disputes in the South China Sea. You have the maritime dispute and the territorial dispute. The maritime dispute has been legally settled with finality by the arbitral award of July 12, 2016. The territorial dispute is outstanding because there is no international court that has compulsory jurisdiction over territorial dispute in this part of the world. So we have to challenge China, submit it to voluntary arbitration, challenge Vietnam, Malaysia, and Brunei. Because the UN Charter says all disputes between or among states must be settled by peaceful means, negotiation, mediation, and finally arbitration. We are in the final stages already because this has been going on for a long time. Now, if these countries do not accept our challenge, then we will go to the Court of World Opinion. We'll tell the world, these are our documents, maps showing that these islands in the West Philippine Sea form part of Philippine territory. And the world must respect this under the principle of iudice possederis juris. We will put it on our website, in the website of the DFA. All of these documents, there are many more that I have not included. So, and we challenge China, show your documents, show your maps. I end my presentation here. Thank you for your patience and attention.
Thank you, Justice Carpio, for that really enlightening lecture. So I hope our students, deans, professors, and other legal education stakeholders learned a lot from this distinguished lecture. So before we move towards the introduction of our panel of experts, may I just address our esteemed colleagues from the Philippine National Police Academy, Aldin Villalon, the Associate Dean of the Philippine Law School, si Attorney Louis Masakayan, the Vice President for International Affairs of ALSP, Mr. Alan Sartorio, from the Philippine Coast Guard, Mr. Romeo Calamaya, Dean of Emilio Aguinaldo College in Cavite, Dean Mario Lucena, from the House of Representatives, Attorney Mark Stephen Reyes, from the Office of Ethical Standards and Public Accountability of the Philippine Navy, welcome po, Sir Eric Alcera. The Executive Director of the Philippine International Law of the Sea Academy, we have Sir Irvin Jules Sape. Sir Dean Kenny Sabellano of the College of Law, Pagadian Capital College. Dean of the College of Law, Bukidnon State University, si Dean Ophelia Pilar Rubio Zamora. And we also have Dean Manuel Kibod of the College of Law of Ateneo de Davao. Welcome po, sirs and ma'ams. So, we are fortunate today to have with us a distinguished panel of experts who will share their insights and reflections from Justice Carpio's presentation. Allow me to introduce our panel of reactors. May I invite, okay. By the order, Attorney John Ray Libiran, the Dean of the College of Law at the University of Baguio. Attorney Ralph Sarmiento, Dean of the College of Law at the University of St. La Salle. Attorney Faisal D. Tanhili, Dean of the College of Law at Notre Dame of Marbelle University. And Attorney Rashid J. S. Sancon, Dean of the College of Law at the Laguna State Polytechnic University. Each of our panelists will now share their reactions to Justice Carpio's lecture. So allow me to invite our panelists by the order I have mentioned. So may I invite Attorney John Ray Libiran to share the stage with us. Let me just... Now, may I request our host to please request to unmute and the video of Dean John Ray Libiran.
Thank you, Gab. I cannot start my video, but anyway. Oh, there you go. Yeah, thank you. Thank you, Justice Carpio, for that nuanced presentation. Otherwise, this information will not be available, will not be accessible to the public, even for my colleagues who are in the academe, probably, unless you are teaching public international law or similar subjects. But what I would like to say this afternoon is it's now incumbent upon us to spread this information. Otherwise, and as shown a while ago, It's unfortunate that we do not know a lot of these things. Um, Justice Scarpio started with really old maps, and they are very interesting, and they give us a lot of ideas of how to go about these claims that we have. Now, remember that before, the technological limitations that we had um, simply did not provide us with any standards of how the territories of an archipelago like the Philippines can be determined. And so if you notice in the treaties that were used, either there were straight lines drawn, or they were referred to as quadrants or portions of territories. Um, but the three treaties that were mentioned by Justice Carpio, the 1898 Spain and U.S. Treaty, the 1900 Washington Treaty, and the 1930 treaty between the U.S. and the U.K., they all point to the facts that were just stated to us. They are very clear. There's no room for interpretation as to what was referred to in those agreements, in those treaties. So the use of that very interesting map, the Velarde Murillo map, and in that it caught my attention, especially that particular island that they indicated there, the Panakot. Now, I came to know that Panakot is an old Malay term, which is also a Tagalog term, if you think about it, that means dangerous or treacherous. And the reason why they called it that is because when they were sailing in that area, a lot of ships get moored or they get destroyed because of the treacherous characteristic of that area. But that was in 1734. That map was issued that time. Unfortunately, for a lot of us, we are limited by the ruling on that we know in the PCA case between the Philippines and China. But as you know, there was no ruling on territory there because it was delivered, it was given in the context of the UNCLOS. And I think that's the message that I want to second, no, that was shared to us by Justice Carpio. The problem is we have a myopic view of our territory. We are looking at our territory in the lens of the UNCLOS only. And of course, that's wrong. Unfortunately, as was mentioned, a lot of our local luminaries, a lot of our legal minds seem to have given up on these claims and sort of ceded those territories on paper and as far as their arguments are concerned. And so even administrations, even our own government, even people who are supposed to act in favor of the Philippines have committed to change these domestic laws to conform to international law, and that's very sad. When the Philippines was ceded to the U.S., as we have learned, for 20 million US dollars and 100, may 100 pa pala yan, ano? What was delivered was not really the group of islands, but a map showing what it was. And that map was corrected to reflect what was really agreed upon. Those maps, make no mistake about it, and in that, as was shown, those maps are ancient maps. They are old, and then the probative value of old things and ancient things, and those maps were not manufactured by the Philippines. Those maps were drawn by a third party. And just to share that this recent, not really recent, but a case between Burkina Faso and the Republic of Mali, which they call the frontier dispute case. In that case, the international court said that maps have corroborative value. In fact, they can be used as evidence to support conclusions. So those maps showed that Spain laid claim to those territories, and the Spanish title to those territories was unchallenged for 300 years. And if that is not open, public, continuous, and peaceful occupation, then I don't know what is in international law. The silence of states, the silence of the states before when these claims were made, led to prescription. Justice Carpio talked about the Las Palmas case and the Max Huber ruling, and the Clipperton Island ruling of King Emmanuel III, saying that discovery of an uninhabited island is enough. It is sufficient to vest ownership, and that is exactly what Spain did a long time ago. Unfortunately, when we were consistent, in fact, the Philippines was consistent in laying claim to these territories. But unfortunately, the U.S. objected when we were negotiating, when we were doing the United Nations Convention on the Law of the Sea. But this objection is really doesn't have to be considered as something that produces legal effect, because in the first place, the U.S. is stopped already. They were the ones who entered into these treaties. They were the ones who asserted the extent of the territories that they said were ceded to them by Spain. And so I think to conclude, let us not limit ourselves to the UNCLOS. Remember that the Philippine claims predates the UNCLOS. The UNCLOS was only in 1980s. It was in 1982. But our claims predate that. And if we are to be faithful to the Constitution, remember, these things are in the Constitution. They are in our domestic law. If we are to be faithful to the Constitution, if we wish to abide by the prescriptions and the prescriptions of our basic law, it behooves us to fight for our territorial claims and heed the suggestions of Justice Carpio to find ways to have these claims put on the table and finally discussed with the rest of our neighbors. Thank you very much.
Thank you very much, Dean Libiran. Now may I invite Dean Ralph Sarmiento, the Dean of the College of Law of University of St. Lazaro. May I request to invite to the floor, Dean? Okay.
Thank you, Gab. Esteemed colleagues, Lab Chair Jason Berlis, Lab Commissioners and staff, fellow students of law, and of course, Justice Antonio Carpio. The last time I was in the same hall, right now virtual, with Justice Antonio Carpio was during the oral arguments of the Team Patay, Team Buhay Tarpaulin case, Diocese of Bacolod versus Comelec, and I was being grilled by Justice Carpio. So at least now I'll be reacting to his lecture. And that is indeed a great honor. So the lecture was, of course, very insightful and comprehensive. Justice Carpio's discourse presents a nuanced examination of our national territories' historical, legal, and geopolitical dimensions, and it serves as an invaluable contribution to the ongoing discourse on Philippine sovereignty. And one thing that I would like to emphasize is the point raised by Justice Carpio with respect to the principle of ut possidetis juris, a doctrine in international law that underscores the sanctity of colonial boundaries as new states emerge from decolonization. Justice Carpio rightly emphasizes that this principle fortifies our claim over the Calayan Island groups, the Scarborough Shoal, extending beyond the limitations of the 1898 Treaty of Paris. His analysis underscores that the islands lying outside the treaty lines, such as the Spratlys and the Scarborough Shoal, were nonetheless part of the Philippine territory, ceded by Spain to the United States and subsequently to the Philippines. And another aspect that I would like to emphasize is the application of the doctrine of intertemporal law in international law. And I think this is very important because, as pointed out by Dean Biliran, the UNCLOS is a new thing. It's a modern thing. It was only adopted in 1982, while we are talking about treaties, Treaty of Paris, 1898, the Treaty of Washington, 1900, and then the treaty with the British sometime in the 1930s. So it's very important that the rights of a state under a treaty must be evaluated in the light of the contemporary or the contemporary law with the treaty. So it must be, so this principle is crucial in understanding the term Philippine Archipelago, as it was understood in 1898 Treaty of Paris, the 1900 Treaty of Washington, and the 1930 Treaty with the British, not as it might be interpreted under the UNCLOS of 1982. And I think that's a very, very important point. And Justice Carpio also lays down the reality of our current situation. So while the arbitral tribunal's ruling in 2016 affirmed the exclusive economic zone of the Philippines and the West Philippine Sea, the territorial dispute remains unresolved due to the lack of a treaty that specifically regulates territorial disputes in Asia. So Justice Carpio's call to challenge China, Vietnam, Malaysia to submit the territorial dispute to voluntary arbitration is a proactive approach, and I believe that, and we would like to support that. So it shifts the burden to these states to justify their claims or accept the prevailing principles of international law that favors the Philippines. So I'm also reminded of the, by way of a reaction, I'm also reminded of the critical role that legal education plays in shaping the minds of future lawyers, policymakers, and leaders. Justice Carpio's lecture is not merely a lesson in international law and Philippine history, it is also a call to action. So it urges us to, especially we in the academe legal education sector, we are urged to educate our citizens, particularly our students, our law students, about the true extent of national territory, the historical and legal basis of our claims, and the need to assert these claims on the international stage with unwavering resolve. So as legal educators, I believe that we bear this responsibility to ensure that the next generation of especially law students and our citizens understand the complexities of our territorial claims and the international legal principles that support them. So I think we must be very, very vigilant, as urged by Justice Carpio. And therefore, I join the call that we must heed the call of the Justice Carpio to challenge the international community and to assert our rightful claims through the power of international law. So with that, I would like to thank Justice Carpio for this very, very enlightening lecture and presentation. And I also would like to thank the Legal Education Board for the opportunity to share my reflections on this very important lecture. Thank you very much.
Thank you very much, Dean. We are also grateful for the opportunity to have you here with us. So for our next reactor, may I invite Attorney Paisal D. Tanjili, the Dean of the College of Law of Notre Dame University. May I invite you both to unmute? Yeah.
Thank you. Good afternoon, everyone. Thank you, Justice Carpio, for this enlightening lecture and for this opportunity. My greetings to the Legal Academy, to our partners, and of course to the Legal Education Board for providing this platform or this forum. Now, by way of a reaction, I would like to highlight few takeaways from the lecture of Justice Carpio. Number one, this lecture actually highlighted that the Philippine territory is defined by a number of important conventions. We understand we are a product of colonial power, colonialism for some time. And because of some concessions, we form or we have this kind of territory based on three treatises or treaties. So it's very important for us to remember. Um, this lecture highlighted the importance of the historical and legal development of this treaties in 1898, 1900, and of course in 1930. In looking at our territory, these things should be closely considered. And it's a challenge for each and every one of us to review, to reread, and appreciate exactly the context why we have this territory based on these conventions or concessions of parties. The other one that I'd like to highlight, of course, is the importance of maps. As highlighted by Dean Chan and Dean Ralph earlier, the importance of these maps, however old they are, is very significant as far as the determination of our territory. I just wish that these maps will be made available to all, to be available to students and all practitioners and legal scholars, so that we can spread it also to and share it with our ordinary citizens, no, or our friends, no, the other people in the country. No? Oftentimes, these maps are only available to those who are engaged in scholarship or those who engaged in litigation, especially in this field. So it's a high time for us to publish this and make this available to everyone, as this will be a basis of our claim, our stature as far as our territory is concerned. The other aspect that I'd like to highlight are some concepts which are important for, especially for students who are starting the study of law, and even as a review for all of us who are in the practice and specifically dealing with this concept of territory. We have concept of discovery and assertion of sovereignty in certain territories or islands that we have seen, especially in this case. Then we have concepts of occupation, which is supposed to be continuous, vis-a-vis concepts of inhabited and areas where there are a number of people. The lecture of Justice Carpio solidify our claim for the areas which were identified outside the lines of the Treaty of Paris, and those were covered by the 1930, 1900 and the 1932 conventions or treaties. It's very important. And then another important factor that I like to highlight here is the concept of Stoppel. No? I realize that very few knew perhaps the position of China, although they did not participate. They submitted a position paper as highlighted by Justice Carpio, and wittingly or unwittingly, they were able to admit that indeed our territory is determined by a number of treaties that we have identified. I just do not know why they do not recognize it and perhaps did not realize the implication of their admission, which is in the highest form so far. And then this concept also of beauty possidetis iuris, which is a concept in public international law, we should give this obligation that should bind other countries to respect whatever we have already identified and have assumed jurisdiction so far for the rest for several years. It's a very important factor that we have to consider. And then another important takeaway that I'd like to share and as a form of reaction. And I agree with my other colleagues when they said that our claims should not be limited or based only on UNCLOS. In UNCLOS, we only deal with maritime zones. The dispute with respect to the Philippines and China were resolved based on maritime claims, maritime delimitations. So the UNCLOS is there, but ours is beyond, especially when it comes to our territorial claims. So we have to consider other parameters, not just in the own clause, which is limited in a sense on a particular aspect like the maritime zones or maritime disputes. So with this, I realized there are, based on the lecture and based on current events, there are a number of challenges that we face, and one of which is, of course, the misconception or the seemingly the divide between scholars, even in our territorial jurisdiction. In our jurisdiction, there are scholars who are not one, or there are scholars who are sharing a different view or different conception when it comes to our territory. So that's, I think, an important challenge on how we can bridge the gap and probably reach that portion where we can have a common understanding of these things. And one important aspect based on the lecture and based on the current events is, of course, the role of the government in supposedly disseminating this information. As we have this afternoon, we are very lucky to have to be involved in this undertaking. So one of which is, of course, as we have now, is the Legal Education Board for providing a platform, revenue, where we can see a perspective from the historical and legal point of view that we have a strong case, we have a strong claim that we should be united enough as far as our territorial claims are concerned. So I thank Justice Carpio for this opportunity. This is a venue where everyone can engage and everyone can be able to see other perspectives that are not, which are not easily discussed or easily distributed or disseminated uh, along the way. And this opportunity is an eye-opener. This is an opportunity also to strengthen our claims or validate our claims over our territory. So thank you, Justice Carpio, and thank you, Legal Education Board, for this opportunity.
We thank you too, Dean. Okay. Once again, thank you very much, Dean, for the very impressive remarks. Reaction. Let me just acknowledge the presence of our Honorable Commissioner, Commissioner Lorenzo R.A.S. Good afternoon po, sir. Okay, to move forward to our last but not the least, the Dean of the College of Law, Laguna State Polytechnic University, we have our reactor, Attorney Rashid J.S. Sancon.
Hello, everybody. Good afternoon. Um, to our esteemed resource speaker, Justice Antonio Carpio, good afternoon po. To all the Legal Education Board family, our attendees in this lecture series, good afternoon to all of you. First and foremost, I would like to express my appreciation to the Legal Education Board for their generous invitation to be part of the first Senator Edgardo Angara distinguished lecture series. So the topic for this afternoon focused on the Philippine Island territories in the West Philippine Sea or the South China Sea. And my reaction on the topic would be on the aspect of geopolitical position of the Philippines, no, based on the lecture of Justice Carpio. So as we all know, South China Sea is one of the most important and relevant security concerns, no? The South China Sea issue at present time. So of course, along with other important issues like climate change, cyber terrorism, food and economic security, natural disaster resilience, and etc. So when talking about the South China Sea or the West Philippine Sea, one cannot disregard the commercial importance of the contested maritime areas. So, based on a Reuters report, the South China Sea serves as a strategically significant maritime area, rich in natural gas resources and facilitating passage of more than around 3 trillion in commerce annually. So while Justice Carpio is delivering his lecture, I cannot help but to ponder on the implications of our victory in the arbitral award in the South China Sea in 2016. And during the discussion of Justice Carpio, one thing is really established: the 2016 arbitral award in favor of the Philippines in its maritime claim in South China Sea against the major rival claimant, China, has concretized the legal claim of our country and confirms our sovereign right over the contested maritime zones in those areas. So there are other six Asian nations claiming over the small islands located in the region waters, as well as the territorial seas around them. As highlighted in the earlier discussions, China's territorial claim in the South China Sea, well, is based primarily on the 9-line, which now I believe is already 10-line, and originally claimed by China to be 11-line. So, of course, this covers around 90% of the water. And these other countries' claimants deny China's position. Although another reality that we cannot simply disregard is that in this region, China has constructed artificial islands with airstrips, military facilities, and ports. It's all over the news. The antagonistic behavior has also led to several confrontations of the Philippine and China's Coast Guard, which of course send alarm to to ordinary citizens of the country. And the recent incidents have led to hamper the economic lives of those fisher folks who rely their livelihood in South China Sea. Many scholars or even commentators said that the escalating tension in the West Philippine Sea are likely to bring another world war. This is by the fact that East Asia is known as site of many of the most powerful military forces globally. So there's this idea on the race to achieve military dominance in the region and around the globe. Of course, that includes China. And such trend is important for the Philippines in terms of national security and national interest. So in view of the conflict in the South China Sea. And this encompasses safeguarding our nation, its populace, and its establishment from invasive tactics of China over our maritime areas. For the past years, we have seen the aggressive invasive tactics of China, in the aggressive stance and action of China against the Philippines, and China's military exhibit consistent growth in strength and sophistication on a yearly basis. The region here in Southeast Asia, which is heavily armed, has experienced a decline in stability in recent years because of these issues. As how I see it, this can be attributed, of course, to numerous territorial disputes between powerful neighboring countries and the increasing assertiveness from China over its claim on the South China Sea. And this also, because of the doubts about the United States' dedication to the region, these factors, of course, we'll know, have resulted in situation that has global security implication. As to the legal standpoint, Justice Carpio provided an extensive and enlightening discussion, provides historical backdrop as what other reactors have said in this in this lecture series about the maps, geographical and legal variables have significantly influenced, of course, the decision to bring the issue international arbitration, which led to our victory in 2016. Listening also to Justice Carpio's discussion a while ago, I think there are 5 important issues that was resolved in 2016 arbitral ruling. And one of those is the verdict No, and of course, supported by the discussion of Justice Carpio on the historical backdrop that China's 9-line lacked legal foundation, and that it was illegal and also incompatible with the UNCLOS on its provisions on the EEZ. Also, another important aspect of the decision is the in terms of Spratly Islands. Of course, it cannot support human habitation, and it's incapable of generating extended maritime zones. So hence, it cannot overlap with islands claimed by China, and with that, the Philippines has exclusive economic right to enjoy the resources in said areas. I think Justice Carpio also mentioned about Ito Aba. Although, if I'm not mistaken, it was not mentioned in the dispositive portion of the ruling in the arbitral award in 2016. However, in the discussion, it mentioned that it was not an island also that can sustain human habitation. And with that, we emphasize on the concept of legal title. Um, if it is a legal title, it means that the EEZ of Palawan is clear. And and with that ruling, we're able to establish the integrity of the EEZ of Palawan. Um, from there, we have to shape not only the nation's national security strategies, but with the help of other countries, adopting a certain degree of cooperative strategy in dealing with China's invasive action in the said maritime zones. Sometimes, I'm hearing some critics and commentators saying that with one what we won in the International Arbitration Tribunal in 2016 is just a paper victory. I do not agree with that. Because of course we cannot discredit the fact that it cemented the claim of the Philippines in its contested maritime zones, and it affirmed its sovereign right over these disputed waters. And also, this has led to actions of other countries to exercise the right to navigation, the freedom of navigation as recognized in international law in disputed bodies of water in the South China Sea. Just to mention, as a reaction of the United States, they sent vessels to the region to safeguard the principle of unrestricted movement, affirming the seas are under global jurisdiction and not under the ownership of one nation. And this is an excellent, I believe, illustration of how an arbitral award is enforced by other countries, and which puts more pressure to China. As to my final words, I believe that the strong institution and more assertive position of the Philippines will have a significant role to ensure and sustain our strong claim of our country over contested maritime waters in the South China Sea. And I support the recommendation by Justice Carpio to bring this a second arbitral case against China. So, and of course, in dealing with conflict in South China Sea, I submit that the Philippines should focus, of course, also in changing its strategies with China. We should not just stick to talks, or some says like a saliva diplomacy. If we really need to fully protect our national interests, we must still adhere to UNCLOS, reject any form of a constitutional concessions, as also highlighted by other reactors in this lecture series. Public awareness is also important, and continuously opposing China's expansionism. And I believe we have to advocate for a multilateral approach and not just bilateral talks that will align with the principal sovereignty, with our integrity, with our territorial integrity and rule of law. So after identifying all of these challenges in terms of foreign relations and national security, the Philippines should look into long term and evaluate the probability and probable consequence of these actions. Now, in the academy, in the legal education, we have a great role in educating the public on the significant issues, as these are not contained in present time, but would have an intergenerational implications. So again, thank you so much and good afternoon.
Thank you so much then po, Dean Sancon. So now to further enrich our discussion, um, if you may allow me, may I invite all our panelists and of course our honorable lecturer and commissioners, if you may allow us, for a series of questions that we curated from our participants. So when I raise po yung question, please do not hesitate to take the mic to share should you have ideas and answers for the questions at hand. So for our distinguished guests, on the topic of economic impact, what are the economic implications for the Philippines if it fails to assert its territorial rights in the Philippine Sea?
Yeah, I can answer that.
Sige po, Justice.
Well, in our exclusive economic zone in the West Philippine Sea, we get 40% of our energy requirement from Malampaya. Malampaya is running out of gas, and the only replacement is Reed Bank. Now, if we don't get Reed Bank as a replacement, and we will be running out of gas in Malampaya by 2027, we'll have to import LNG, and that will be very expensive. The estimate is our power rates will go up by 50%. That means foreign investors who have located here cannot compete with their rivals in Vietnam or in China, so they will have to leave. And with the power rates going up by 50%, there will be a terrible inflation, and workers will demand higher wages to keep up with the higher prices. There will be unrest.
Yeah.
We will have 12 to 14 hours of brownout if we don't import LNG. So we have to import LNG, but it will be very expensive. So our economic survival depends on getting that gas in Reed Bank. Otherwise, we'll have to suffer very high power rates. That's the economic side. The other side is we get about, by some estimates, about 18 to 20% of our fish from the West Philippine Sea. So if we lose the West Philippine Sea, if we lose our EEZ there, we lose the fish that we get there, about 20% of our annual fish catch. So right now, our galunggong has gone up in price, maybe doubled the price since President Duterte took office. And so we are actually importing galunggong. And where do we import it? From China. And where does China get the galunggong? From the West Philippine Sea. It's our own fish that's being sold to us. So we just have to really protect our maritime zones in the West Philippine Sea. And there are other minerals like the methane hydrates. The fuel of the future is methane hydrates. These are ice crystals which form around gas. So this is actually gas. There's now a technology to get that gas very deep in areas of the deep sea where ice crystals form. And methane hydrates are more abundant than oil and gas combined. So if we run out of oil and gas, we have to use methane hydrates, and they are very abundant in the West Philippine Sea.
Yeah.
So there are other minerals that we haven't really thought of that could be found in the deep sea bed. So we must protect this for future generation of Filipinos. Can you just imagine if we don't have these mineral resources? So a lot will be taken away from us if we don't preserve our maritime zones in the West Philippine Sea. Thank you.
Thank you po, Justice. From our reactors, do you want to add on, or would you like to move to the next question?
Yes, sir. I could add some. Yeah, I agree with Justice Carpio's statement a while ago about our loss of access to vital minerals, deposit, and natural gases. And there are also, when we look at this issue, we're looking at the national security, and we should expand that concept of national security into food security, considering that the overfishing of Chinese and construction of artificial highlands have caused damage, severe harm to our coral reefs, which is, of course, important to our marine ecosystem and would impact the lives of our Filipino fisher folks and threatens the food supply. I think another important aspect, no, on the economic side, I mentioned a while ago that it could reduce trade and economic security, because if China will be able to have full control on the South China Sea, that's the problem. They could put some control on international shipping routes, particularly damaging or harming the Philippines, which heavily relies on trade. Another important aspect, I think, is that in the West Philippine Sea, we have natural wonders. We have beautiful beaches. We have coral reefs, pristine coral reefs that is valuable to our that is valuable to our tourism industry. And I believe that degradation of these natural wonders, these natural resources, due to the China's continuous construction and even militarization of the area, would result to ecological damage, which would lead into tourism revenue loss. So I think those are some things that I think we should consider. We should look into.
Sige po, Dean Libiran.
Yeah, yeah, I just would like to clarify, because a lot of you might be wondering, and you might be saying, oh, but this is part of our exclusive economic zone, meaning we have the rights over all the living and non-living things there. But we should not be confused with that, because there's a distinct difference between an exclusive economic zone and a territory. Remember that in the EEZ, you still have the right of overflight. No, you have you cannot restrict the right of navigation, and all of these things. These are creating problems for us right now, especially with our neighbors, because they are preventing our citizens from exercising that. And so it's not enough to just consider them as exclusive economic zone. They have to be claimed as a territory that's capable of even generating all of these maritime zones.
Thank you very much, Dean. Definitely, I think this is connected to my next question. So on the topic of national sovereignty. So a question here is, what is the long-term impact on Philippine sovereignty if the current status quo in the West Philippine Sea continues? So may I invite po our reactors, possibly our commissioners, if they have, I think, ideas on the question.
If I may, sir.
Yeah.
Sure po.
Yes. It will have a long impact. It would be, I think, a grave impact if we will not act accordingly, if we allow China to continue. While we distinguish things in the exclusive economic zone, some of us will have to determine some sovereignty and then some issues on sovereign rights. But China is trying to erase all kinds of distinctions. While we try to comply with certain rules and international law, China is trying to erase certain compliance and impose their own liking. So they would like to impose their own understanding and perspective over it. I think we have already seen, as I agree with Dean Rashid earlier, everything has turned into a security problem. If we expand security not only in terms of armed conflict, but also when it comes to food security, everything has already been expanded because of this action of China. Yun ang challenge on how exactly we have to, or how can we possibly get China to follow exactly the rule of law along this line. But we have to continue. As earlier explained, there are certain avenues we can do bilateral talks, which turn to be not productive enough. So we should engage in multilateral engagement, no, with other countries involved or partners. While we disagree, as noted in our national policy against aggression or any other form of resolving disputes outside peaceful means, they should pursue. No? The one mentioned by Justice Carpio earlier is a good option. Eventually, international opinion, eventually, all other legal remedies that we will have to pursue, I still believe, I am convinced, I am 100% optimistic that so long as we do not stop and eventually show China, together with our partners, that we know what our parameters, we know our rights, and then we can actually assert it, and then there is a forum, there is a partnership or collaboration with the international community. I think we can do that. If we will stop, I think we have seen that already in the past several years, and there seems to be no stopping on the part of China. Thank you, sir.
Dean Ralph, do you have anything to add po?
Thank you very much. Just a follow-up to that. I believe that sovereignty is not, it's something that we must nurture. It's something that we must protect. It's something that we must be really vigilant, in protecting. Otherwise, we might just end up one day and then wake up and then we lose all titles to all these islands. Now we have evidence on paper that we own them and that we have a right to, that we can assert the right over them. But the realities of international law is that, it's not enough that we have this in paper. The exercise of sovereignty, assertion of sovereignty is very important. Otherwise, there's also a concept of just like in civil law, the concept of prescription, because of continuous occupation and assertion of contrary rights by other states. Eventually, we might lose our claims. So I think this is something that we must continue to assert and that we should not stop asserting.
Okay. Thank you very much, Dean. For the next question, we have this is themed on global repercussions. So how might the outcome of the West Philippine Sea dispute influence international maritime law and other territorial disputes around the world? So are there anyone willing to answer?
Let me tackle that now.
Okay, Justice.
The world order now is based on the provisions of the UN Charter, which says all disputes between states must be settled by peaceful means, negotiation, mediation, and ultimately arbitration. And second, in the settlement of disputes, the threat or use of force is outlawed. So the framers of the UN Charter said, we have to adopt this new principle because before the 1945 UN Charter, the rule was might is right. So because of that rule, might is right, if there's a dispute between two states, they can settle the dispute. One state can settle the dispute by invading the territory of another state. And if it wins, then the territory that's taken is legitimately the territory of the state that won the war. And that's why we had continuous wars. World War I, World War II, and in between and before that, a lot of countries were constantly at war because the principle was might is right. So the UN Charter, when the framers wrote the UN Charter, they said we have to stop this because there is now the nuclear bomb and the Third World War would mean the end of human existence as we know it. So the international world order is now governed by these two principles of the United Nations Charter. Now, what China is doing is to overturn this by threat of force. China passed a law saying that they can use force to enforce their claim in the South China Sea. That means to make the 10-dash line their national boundary. So this law by itself is a threat to all of us, to all countries around the South China Sea. That is in violation of the UN Charter. And if China succeeds, that will overturn the existing world order. And that means might is right will prevail again. And of course, countries like us, non-nuclear powers, will all be subjugated by nuclear armed states. In Europe, Russia invaded Ukraine using force to settle a territorial dispute. That is against international law. That's why the UN General Assembly overwhelmingly condemned Russia. But if both China and Russia, China by threat of force, Russia by actual use of force, overturn the existing world order, we will be in a terrible, terrible world. There will be constant, the nuclear powers will constantly dominate, will take over the small countries. So we have to fight this. This move by China and Russia to overturn the UN Charter is what is the greatest battle that we have. I'm not looking only at the South China Sea. I'm looking at the overall picture in the world, because what's happening in the South China Sea is happening also in Eastern Europe, and will affect the entire world, because the very foundation will be changed. The legal order will be changed. It will be might is right again. And you have to be a nuclear power to survive. Otherwise, you will be colonized or you will become a satellite. That's the way I look at it. Thank you.
Okay. Thank you very much, Justice. I think a question connected to that would be on the topic of enforcement. Given China's disregard for international rulings, is the Philippines doing enough to safeguard its interest in the region, or should more assertive measures be considered? If possible, if there are possible assertive measures, maybe we can, I mean, what are those assertive measures that the Philippines can consider doing?
Well, first of all, there are 5 nuclear armed states that lost in arbitration. And of the 5, only Russia has refused to accept the arbitration. The U.S. lost in the Nicaragua case, U.S. versus Nicaragua versus the U.S. And eventually, the U.S. paid damages in the form of aid. They did not call it payment of damages, but Nicaragua accepted aid as compensation, because of course the U.S. will never agree that it violated international law. But that's between Nicaragua and U.S. If Nicaragua accepts that kind of payment, then it's okay. So I consider that compliance. Second, Russia lost to the Netherlands in the Arctic Sunrise case. Russia said, we will not comply, we will not honor, the tribunal has no jurisdiction, but eventually China paid damages. They talked to the Dutch and said, we're willing to pay, but let's bring it down. And so the Netherlands accepted the lower amount, and that was a compliance. Third, you have the Bangladesh sued India in the Bay of Bengal arbitration. India is a nuclear armed state. India lost, and immediately India said, we will comply. Fourth, you have the Mauritius versus UK. UK is a nuclear armed state. Mauritius won in that ICJ opinion. And the UK said, we will comply. It's only China that has not complied. So China is really an outlier, and we should not be disheartened because the record is there has been 80% compliance. Only of the only China has not complied. But that's why we have to put pressure on China by getting the rest of the world to support us, pile up more orbital awards against China. This is a long-term battle. So we should not be disheartened because China is not the type of country that will just roll over when it gets hit the first time. We have to keep up the pressure. We have to develop alliances with other countries. So the game is not over. This will be a long playing battle with China. And we need the assistance of the world. The world will support us because it's the rule of law. Because as one of our diplomats said, about 60% of the countries of the world are small states like us. And they are worried that their bigger neighbor might grab their maritime zone. So they will be with us. So we should continue this struggle because we really don't have any choice. Thank you.
Yes, definitely, Justice. To our reactors, maybe this question would spark some ideas on the possible. Maybe we can ask for ideas on some possible inputs. So the question is, what are some realistic, achievable outcomes that the Philippines can expect in the next decade regarding the West Philippine Sea, following the discussion of Justice Carpio? Or maybe our commissioners, if you have insights.
Let me give my comment on that also. Many people are saying that the orbital award cannot be enforced because China refuses to acknowledge it. On the contrary, the orbital award is enforced every day. Whenever the US and its allies sail in the West Philippine Sea, they tell China, this is the exclusive economic zone of the Philippines. We can sail here, we can conduct naval drills here. This is not your territory. So that is an enforcement. If you just imagine if today the US and its allies withdraw from the South China Sea, immediately the 10-dash line becomes the national boundary of China. Nobody can oppose China among the coastal states in the South China Sea. So the orbital award is actually being enforced every time the US sails and conducts naval drills. Because China is saying that's our national territory. You cannot conduct naval drills. You can pass by our forbearance. We tolerate. You can pass. That's tolerance. But you cannot conduct naval drills. But they conduct naval drills all the time. So they rebut China. China cannot enforce it as its national territory in the water. So there is enforcement actually. And that's why I said, let us invite all the navies of the world to sail in the West Philippine Sea, to conduct naval drills there. Because if they do that, they are actually enforcing the orbital award. Thank you.
Thank you for Justice.
I think
Go.
it's also it's also very important that all of us should be vigilant in terms of, for example, exercising our right of suffrage in electing leaders, political leaders, that will support these measures of enforcing our rights, because that's very crucial, and critical that we have such leaders. Because otherwise, if our leaders are not supportive, or they do not, let's say, they do not believe in our claims, then of course we lose our claims automatically. Even Justice Carpio or us, deans of colleges of law, or ordinary citizens, we can only do so much in terms of educating law students and our citizens with respect to these claims. But if the government will not be proactive in enforcing these claims, in taking all the possible measures to assert our claims, then I think all our everything that we do will be futile.
Definitely.
If I may, sir.
What do you-
The arbitral ruling, for me, is a very symbolic thing. Number one, it shows our boldness, as a Filipino, and we thank those who actually initiated and participated in the filing of the case. It shows that there is an alternative. There is a particular way or means of at least enforcing our rights and making the world that we have this. Second, I think it's one important aspect that we have seen in the arbitral ruling is it exposed China's loose ends. Through the ruling, we were able to discover and eventually made known to the whole world that China is not actually on the strong ground. And it exposes some of their mischievous claims, some of their strategies, and actually give them a sufficient warning. So we may probably be lacking on certain physical or actual um, enforcement on that aspect, but I still believe we have, no? And together with the other help of our partners as demonstrated by Justice Carpio earlier. But this is the first step. This is the first step, and China realized, I suppose they realized it, although they probably recognize it. So two things, it shows our boldness. We have seen the alternative, we have seen the venue, we have taken advantage of it, and we expose China along the way.
Mhm.
Yes.
Sir, can I add just
Sure.
just a little, just a short comment? Um, Although military, of course, confrontation is, of course, it's not really ideal, but we have also to project power. I think we should also strengthen our defense capabilities, because we should, of course, increase our naval and coast guard patrols. With that, we will be able to show that we have a strong resolve in asserting our sovereignty and our sovereign rights over um, the the uh, the contested maritime areas. And regular presence, of course, could show China of our deterrent against their aggression. I think it's also time, of course, that we invoke and to leverage on the mutual defense treaty with the US, like what Justice Carpio mentioned, joint military exercises, the Balikatan, the US support whenever operation can definitely reinforce the Philippines' capability to respond threats in our waters in the West Philippine Sea.
Okay. Sige po, Chair. Do you have anything to add po?
Yeah. Ano lang, ano, yung sa katanungan na ano ba ang pwedeng mangyari na makatotohanan sa loob ng 10 taon. Siguro ang tignan natin, ano ba ang gagawin natin doon sa mga susunod na taon, no? Napakaganda nung mga suggestion kanina, nandyan yung mga mungkahi ni Justice Carpio. Ganda rin ang punto ni Dean Ralph, no, na iboto natin ang mga taong alam natin na magtatanggol dito sa issue na ito, no. Pero sa atin din bilang mga ordinaryong mamamayan, ano ba ang pwede nating gawin? Lalo na sa atin na mga nag-aaral o nag-aral ng batas, no? Nakita natin kanina, napakaganda nung pakita sa atin ng discussion ni Justice Carpio. Naintindihan natin. Ngayon tayo na nakakaalam nito, ano ba ang ginagawa at ano ang gagawin natin para yung mga ordinaryong mamamayan ay matutunan din ito, malaman nila at isapuso nila ang mga bagay na to, no? Kasi kung tayo bilang isang Pilipinong komunidad, isa sa puso natin lahat ito, no? Marirealize natin na oo, dapat iboto natin ang mga taong magtatanggol para dito sa posisyon na ito. Ano pa ang pwede nating gawin? Tayo rin mismo magpakita ng paglaban, no? Magpakita ng paglaban na hindi natin ito-tolerate ang mga ganitong klaseng mga agresyon, no? Sa ating mga pangsariling gawain, di ba? Tinatanong ba natin ng sarili natin, okay, mas mura ang Chinese-made product. May available naman na ibang produkto. Tinatangkilik ba natin yung produkto nila kasi mas mura, mas convenient para sa atin. Mga ganitong bagay, kung lahat tayo bilang isang Pilipinong komunidad ay magtitipon-tipon, magsasama-sama at ipapakita na meron tayong ginagawa, no? At suportahan ang ating mga namamahala, no? At suportahan ang mga initiatives ng ating gobyerno, ipakita natin na tayo mismo nasa likod nila sa lahat ng ginagawang ito. I think merong mangyayari kahit sa loob ng 10 taon na yon. Yun lang po.
Thank you, Chair. Yeah, I think Com Lawrence, would you like to add?
Yes. Thank you, Gab. My question is to the Honorable Justice Carpio Lawrence here, Justice Malcolm Horn. My question is, should we accept the offer of the United States of America to escort our Coast Guard and Navy boats every time they travel to Ayungin Shore to supply our troops there or to Skoda? Naka-offer yata silang i-escortan nating barko pero hindi yata tinanggap ng Chief of Staff. Maraming salamat po.
Well, my position is initially I said we have to do it ourselves. But if we cannot do it ourselves anymore, we should accept the offer. I think the point has been reached because you can see that we are forced to leave Skoda Shoal, but there was no replacement. I understand we sent a smaller ship, a 44-meter ship, but that shoal is surrounded by Chinese vessels, and they will probably stop that 44-meter ship, just like what they did few weeks ago when they stopped the same ship that we sent there. It was on its way also to Skoda Shoal. So that's a small ship, 44-meter. Teresa Magbanway 97. It's about bigger than any of the Chinese ships there. So we have only two big ships, Teresa Magbanway and Melchora Aquino. So if the Chinese is already rammed and punctured Teresa Magbanwa, and they can do that to Melchora Aquino, and then there's nothing we can do because we have very small ships. So I think it's time to accept the offer. Otherwise, we will lose Skoda Shoal. So, and the U.S. is our defense partner. Mutual defense treaties are allowed, expressly allowed under the UN Charter. Individual or collective self-defense is allowed. This is collective self-defense. So it's part of international law. So, and our choice really is, if we don't accept assistance from the US in this regard, we could most likely lose Skoda Shoal because the Chinese know that if we send another ship there, it will stay there also in Skoda Shoal. Haharangin talaga nila. So, but if the US will escort us, as like what happened to Malaysia. Malaysia surveyed and drilled in their EEZ. The China said, you cannot do that. That's within the 10-dash line. There will be war if you do that. But Malaysia proceeded, and at the same time, US and Australian warships were there in the same area conducting naval drills. The Chinese Coast Guard couldn't do anything. So it's not something that's unique. We can do it. It's about time, I think, because the alternative is to lose Skoda Shoal. And I don't think we should lose Skoda Shoal because that's very near. The Philippines. It's about 75 nautical miles, no? It means Chief Reef is further, it's about 120 nautical miles. So China will continue its creeping invasion until it occupies everything within the 10-dash line. And we cannot allow that. Thank you.
Thank you very much po. Sige po, Dean
Justice,
Lipian.
thank you very much.
Yeah, thank you. This is also in relation to that the previous question, but I would like to direct this specifically to Justice Carpio, sir. So the question was, what concrete thing can we do in the next 10 years? And I was just thinking of that case in regarding the International Criminal Court, where some people filed a case of mandamus to compel the government to you know to do something about the withdrawal of the Philippines in that in the Rome Statute. Now, is it possible, Justice? Because it's a duty. It's the sworn duty of the government to protect the Constitution and to enforce domestic laws. And our claim to these territories are found in the Constitution itself. It's in the 1987 Constitution. It says part of the national territory are territories over which we have sovereignty and jurisdiction. And as you have discussed a while ago, these are based also on historic rights and those three treaties. And so can we file a case of mandamus? Can we compel our government to file a case in the international court to force them to go to the ICJ?
Well, the chief architect of our foreign policy is the president, and as chief architect, he can choose from the many options available, and going to the an UNCLOS tribunal is one option only. There are other options. So I do not see the Supreme Court granting any mandamus because it will defer to the wisdom of the executive. But I have been. It takes time, no, to when I started my advocacy to convince the government to file an arbitration case for the first arbitration case. It took some time, and when I talked to Secretary Del Rosario then and explained to him why we should go to an arbitral tribunal, and he said, "Okay, I'll talk to the president." And when he talked to the president, President Aquino said, "Why do you want to sue China? China has not done anything to us." But a few months later, China seized Scarborough Shoal, and that's why he changed his mind. No, what I'm saying is it will take time. What I'm recommending now is we file a second arbitration case for damages because they have damaged our Coast Guard vessels, and it's slowly being accepted by some people. Eventually, the president will have to decide on that because the president is the commander-in-chief, and the commander-in-chief of the Philippine Armed Forces that is tasked specifically by the Constitution to defend Philippine territory, including its maritime zones. So if he does not defend, then he can be impeached. People will say, why aren't you doing anything? And that's why President Aquino then said, okay, we'll file the arbitration case to show that we're doing something.
Yeah.
Because otherwise, he would be inutile. So, and I think that the time will come when President Bongbong will have to file a case because he will have to do something in case China seizes also Skoda Shoal, the same way that China seized Scarborough Shoal. When China seized Scarborough Shoal, we did not send the Marines to retake Scarborough Shoal because we didn't have enough firepower. We sent our lawyers to The Hague. And that's exactly what's going to happen, the way I see it. But we have to press the president that you are the commander-in-chief. You have to defend as commander-in-chief of the Philippine Armed Forces. Your task is to defend, to preserve our territories and maritime zones. But what are you doing? So he will have to file a second case because we cannot send our Coast Guard or Navy to score the shoal if there are 200, 300 Chinese vessels there. We are outnumbered, outgunned. So it takes time for the bureaucracy to understand that. That's my experience. So slowly now they're accepting it that yes, we may file. So we will have to press that they should file. And China actually dreads another arbitration case because Wu Shikon, the guru of China in the South China Sea, actually convinced the Chinese leadership to claim everything within the 10-dash line. Not only islands within the 10-dash line, but islands in all the waters, which is really against international law. He convinced the Chinese leadership. And Wu Shikon said, even if we are not recognizing the arbitral award of 2016, it has a negative impact on us that cannot be erased. And that is why we should stop the Philippines from filing another arbitration case. He said this publicly. It's published. So because another arbitration case in our favor will mean the countries of the world will rally around that arbitral award. And that is really the potent weapon that we can use against a nuclear armed state. I mean, if we're no much, let's admit it. China is the largest navy in the world, the largest Coast Guard in the world, the largest submarine force in the world, the largest standing army in the world, the second largest economy. We are no much. So we have to rely on international law and rely on our allies. So we have to push this government to use the rule of law, bring the case to an arbitral tribunal. We cannot lose if we bring this to an UNCLOS tribunal because that's clearly against UNCLOS. Thank you.
Thank you po, Justice. Lawrence, do you have a question po?
Yes, thank you, Gab. Another question for Justice Carpio. Last Tuesday po, si retired Ambassador Hermenegildo Cruz suggested that the Philippines file a petition before the United Nations Security Council and subsequently to the United General Assembly to get the sympathy of the world community. Are you in agreement with that, Justice?
Well, I've said that we should go to the UN General Assembly to get the support of the world because I think we will win there. But I caution that it's not just a matter of filing and asking the members to vote. No, this requires a lot of hard work. Before we file, we should talk to them. That means a lot of lobbying. That's the reality of it. We lobby. The US has said that they support us, so we will ask the US, what are the countries that you can convince to help us? The UK said they will support us. We ask UK, help us convince the countries close to you to support us. France, all the EU countries, Japan, because what they're saying is, China will win in the UN General Assembly because China has been given a lot of aid to African countries, to Latin American countries. I said, yes, but our allies, if you put them together, they have given far more aid, assistance to other countries. So if we can galvanize our allies to counter the Chinese influence, we can beat China, but it requires hard work. It's not a matter of filing the resolution now and getting the vote tomorrow. That will not happen. We will lose. So what we will do is we must have a strategy. We talk to our allies first. This is what we do. Can you talk to your close countries close to you? Because that's reality. China would give a lot of aid to a small country, but expect that small country to vote with China. That's how it goes. That's how it goes. So if you combine the aid given by all the countries supporting us, we can easily beat China. But we will have to do our homework. So the proposal of Ambassador, who's his
Cruz,
name?
Cruz,
Cruz, that's
Cruz.
okay, but we need preparation because if we file with the Security Council, we'll surely lose because China has a veto power. Then we go to the General Assembly under the Uniting for Peace resolution. But before we do that, we should have talked already to the members of the UN because we have to win by an overwhelming majority here. That's the point. So yes, we can do that, but it requires a lot of hard work. And as far as I know, the DFA has not started doing that. Thank you.
Thank you very much,
Thank you,
Justice.
Justice.
Okay. And thank you very much, Justice, and our panel of reactors, as well as our commissioners and chairperson. Since we have most of our participants here being that of your law students and professors, may I ask each one na lang po for a short, very short takeaway message from our panel of reactors. Maybe we can start po kay Dean Ral.
Well, so ganun lang. Thank you very much for this opportunity. It is indeed an honor. And thank you to Justice Carpio. That was a very, very important lecture, something for our generation and for the next generation. It's very important that we have this lecture in order to not only to educate but to campaign for the assertion of our sovereignty and all our claims to what is rightfully ours in the in this vastness of the territory waters surrounding our territory. Thank you very much.
Maybe have Dean Rushid po.
Yeah, thank you so much. Again, thank you so much for this opportunity. Really honored to be part of this first distinguished lecture series. Major takeaway, I think, is that for the next decade, I think it will be very difficult pa rin, or the issue in the West Philippine Sea will not be resolved immediately, but we could achieve some practical or realistic outcomes by having some balanced approach. No, we maintain a peace and stability. Let's look into diplomatic channels. Continuously look into diplomatic channels. We have to strongly enforce our rights based on the arbitral ruling, our fishing rights, environmental protection. Like what I mentioned a while ago, we have also to strengthen our military presence and continuously secure international support. So that's all, and thank you again. Good afternoon.
Thank you very much, Dean Rushid. Maybe we can invite then si Dean John Ray, and then we'll have Dean Tanjili po.
Yeah, thank you. I'd like to thank LEB for this forum. For one, most of the talks that we hear about the West Philippine Sea really centers around the arbitral ruling. But this one that was just made by Justice Carpio is really something that we ought to know. And so the key takeaway for me is for us everyone to study this further. Otherwise, we will not be able to discuss this even in our schools, because simply public international law has a definite coverage, and rarely do we discuss stuff like this there, except probably in the graduate school. And so Justice Carpio has been studying this for a long time, and it's really valuable, and we should follow suit. We should study that. Because it's not just about UNCLOS, as we have learned today. It's not just about UNCLOS. It goes further than the UNCLOS, and there are so many things that we ought to know about this. So thank you for inviting us to be the reactors, and thank you, Justice Carpio, for that very enlightening talk.
Thank you, Dean. Okay. Dean Tangili.
Yes, good afternoon again. Thank you, Legal Education Board, for inviting us. This is indeed a great opportunity and an honor for us, and also to Justice Carpio. I'm happy that part of the core syllabus in Constitutional Law 1, which I'm currently teaching, we also discuss territory. And thank you for the videos, Justice Carpio. Some of the videos are actually posted online. So we borrowed some of the videos to enlighten our students. And here today, we have you personally discussing the details. So the Philippine territory and all the parameters about it, I am personally elated with the directions that you have shared with us. The details, the legal, historical, geographical, geopolitical aspect of our territory. So I noticed this not only as enlightening as far as the legal academy is concerned, as far as the students of law, but I also find this as empowering as far as our ordinary citizens, all of us, to have this kind of information. So we wish everybody well, and we wish that the same activity will somehow be undertaken in the coming years, especially so that this issue of territory is definitely linked with our survival, our perpetuation as a nation, as a people. Thank you. Thank you very much, Justice. Thank you very much, everyone.
Thank you very much. Also, Dean. Thank you to our distinguished panel for their thought-provoking insights, as well as our sincerest gratitude to our inaugural lecturer, retired Senior Associate Justice Antonio T. Carpio. May I invite everyone, our 500 online participants, to please give an online applause to our distinguished lecturer. Okay. As we draw this afternoon's discussion to a close, some takeaway message po, Justice?
Yes. Well, my purpose here in giving this lecture and in talking to the Filipino people on Philippine territory is to ensure that we are on the same page when it comes to Philippine territory. We are fighting China, and China is the hegemon in our part of the world. It is much bigger than us. It is much powerful than us. We cannot possibly fight China if we are divided. The only way to win against China is that we are unified. We have the same historical, legal, and political narrative. If our legal luminaries will say the Spratlys, the Scarborough do not form part of Philippine territory, then how can we win over China? So we have to be on the same page in the territorial dispute as in the maritime dispute, because we are fighting a country of 1.4 billion people. And in China, from grade school to college, they are taught one thing, that they own the South China Sea since 2,000 years ago. So we have to be very strong in our arguments. We have to be united, and there should be, as much as possible, very few people who will Filipinos who will go against this, because we cannot win if we are not united. And we have to convince not only our own people, we have to convince the rest of the world to help us convince China. Because China will not simply roll over, even if we've won already in the July 2016 award. They will take a lot of awards. It will take a lot of convincing the rest of the world to help us. And we are gaining traction. When the award came out, there were hardly voices in our favor because our own president didn't support it. But now we see even South Korea, even India supporting us now. And the entire EU is now united. When the Turin came out, Greece was very lukewarm because Greece wanted to get investments from China. But now they're more united because they understand the value of the rule of law, especially Greece, as it's fighting Turkey over islands in the Mediterranean, uh, in the in the off the coast of Turkey. So we must be united. You must be on the same page because we're fighting a very powerful country. We cannot afford to be divided on both the territorial dispute and the maritime dispute. So I'm presenting this because our historical narrative on our territory must be airtight. We cannot have one former Solicitor General saying, we only claimed since 1978. Talo tayo.
Mhm.
We have to, because China claimed it earlier. And factually, that's also incorrect. So let us have one legal narrative for the territorial issue and another for the maritime dispute. We have one already in the maritime dispute. It's a matter of enforcement now. That is final and binding. It's only China that refuses to accept it. So we have made big strides there. On the territorial dispute, that's another issue. We have to first be united. And I'm happy that President Marcos, in his speech at the Shangri-La last August, he said Philippine territory is not governed only by the Treaty of Paris. That was amended by the Treaty of Washington. The first time that a Philippine president said that, despite the fact that's already there in the 1935 Constitution. So it's all there. The answer really is there in the 1935 Constitution, but we have forgotten. So we have to reconstitute all of this, present it in a coherent manner, and I think the world will support us here. So that is all. Thank you.
Once again, thank you very much, Senior Associate Justice Antonio Carpio. Thank you so much as well to our more than 500 online participants today. And as we draw this afternoon's discussion to a close, we would like to invite Commissioner Salex Espinosa Libogha of the Legal Education Board to deliver the culminating message and closing remarks.
Good afternoon, everyone. On behalf of the Legal Education Board, we would like to extend our sincerest gratitude to retired Senior Associate Justice Carpio for the extensive and comprehensive discussion of the West Philippine Sea territory, and also to our panel of reactors, the 4 esteemed deans, and our participants for their active participation. Thank you for your interest, thirst, and hunger to learn from this challenging issue of the West Philippine Sea. This has been a very productive and engaging discussion this afternoon. I hope that the takeaway messages that we have gathered this afternoon will be cascaded not only to our law students, but also to our children, as well as to the community. As what Justice Carpio has said a while ago, we need to be united in the quest for our freedom and defending our West Philippine Sea. I would like to start my culminating message by borrowing the words of Justice Carpio in a long line of articles that I have read in the journals as well as in newspapers. I love some of the quotes of Justice Carpio for West Philippine Sea, and I quote, "The battle to defend our sovereign rights in the West Philippine Sea is also a battle for the hearts and minds of the Filipino people and the world." I hope that history will not repeat itself, that we were able to attain our freedom for almost 300 years from Spain, and of course from the Western colonizers, the United States and Japan. And I hope that for the next decade, we will be able to realize very productive outcomes of West Philippine Sea. The distinguished lecturer has elucidated and illuminated clearly and distinctly the antecedent facts, historical, geographical doctrines, and legal basis of national and international law, which form part of our legal right in the West Philippine Territory. We greatly appreciate that, and I hope we have been enlightened properly against the propaganda of China. The esteemed deans have provided a more enriching and enhanced insight in their reactions regarding the issue at bar, with their substantial and comprehensive reaction to the discussion of the Honorable Retired Senior Associate Justice. I quote in some of the articles published that in this modern day battle, the best and brightest legal warriors in our country today must stand up and fight to free the exclusive economic zone of the Philippines from foreign encroachment like China. In this historic battle to secure our territory and our rights and our resources in our exclusive economic zone, we must rely on the most powerful weapon invented by human beings to settle the disputes among states, and that is peace and security, not might and power in the battlefield between small nations and superpowers. In the study conducted by the University of the Philippines in 2016, apart from the defense of sovereignty and territorial integrity, development and proactive diplomacy based on Philippine interests and needs should be placed front and center of the next stage of the Philippine statecraft on West Philippine Sea issue in the next decade, whether through bilateral negotiations and alliances with China or regional cooperation in Western and Eastern countries. As exemplified by our speaker, law and diplomacy will remain instruments rather than ends in themselves, and the objectives of our foreign policy will remain the security of our state, the welfare of people, and peace in the region and in the Philippines is of paramount importance. Thank you to our distinguished lecturer, reactors, participants, legal education board officials, our programs and projects office for this novel undertaking, the first and inaugural Senator Edgardo Angara lecture series. Let's continue our conversations and intellectual discussions to uphold the rule of law and justice. At the end of the day, we need to protect our sovereignty, sovereign rights, territorial integrity, national and economic resources. To close, I would like to borrow again the words of Senior Associate Justice Carpio. That weapon, the great equalizer, is the rule of law. And under the rule of law, right prevails over might. Happy National Law Week to everyone. Thank you and God bless.
Thank you very much, Commissioner Alibogha, for your inspiring message. And thank you once again to Justice Carpio, our panelists, and all of you for your participation for today's event. We hope the discussions today have sparked new ideas, inspired greater engagement with the critical issues surrounding the West Philippine Sea, and most importantly, deepened our collective understanding of how we can safeguard the future of our nation. This is Gabriel Matol of the Programs and Planning Office, and on behalf of the board, we wish you all a pleasant afternoon. Maraming salamat po. And for our participants, we invite you po to accomplish our feedback form presented in the screen. Once again, thank you very much and have a pleasant day. For our participants, we will close the meeting room in exactly 4 o'clock. So please make sure to answer the feedback forms so that you may receive your certificate of participation.